latest in the lawsuit that the National Shooting Sports Foundation has against the state of Illinois' firearm industry liability law has a federal judge granting the plaintiff's motion to file supplemental notice in the challenge against that law, citing the law being used by the city of Chicago to sue Glock. Welcome back. Bishop on air, hanging with you this morning, each and every morning. Like, subscribe, hit that notification bell. So we've been talking about, of course, a lot of the litigation against various gun control measures in the state of Illinois. And we still have pending the Southern District of Illinois Federal Court in their case, moving forward with the merits of the gun ban that was enacted in January of 2023. So that case is still playing out, right? They're getting all their discovery together, their experts and such. And we'll touch on expert witnesses and what those ultimately cost, especially when the taxpayers are the ones footing the bill for the state to defend a gun ban, like in Illinois. The Firearms Policy Coalition has an interesting graphic that shows just how much at least one expert was getting in a whole bunch of different cases. Regardless, the Southern District case, that case continues. And we do have a deadline, I believe, tomorrow of some more filings that need to happen. That case, many speculate you'll have a trial and it'll have some kind of outcome by this summer, maybe by the 4th of July, Independence Day. We shall see. But that's the gun ban lawsuits. But you have other litigation like this National Shooting Sports Foundation lawsuit against the state's gun industry liability law. And on Monday, after last week Chicago sued Glock, you have the National Shooting Sports Foundation saying, look, federal judge in the Southern District, separate case, this is happening in Chicago. They're using this state law we're challenging in federal court to go after Glock, and that's why we need to have this law struck down by the federal courts in the state of Illinois. So the judge in that case yesterday did order that the plaintiff's motion for leave to file notice of supplemental authority is granted and that the court will review the attached pleading from the Circuit Cook County Court with respect to the pending motions. And there are some pending motions to dismiss because of a lack of standing or because nobody's been hurt. That's what the state says. But of course, the plaintiffs in this case pointing to the city of Chicago's lawsuit against Glock as a reason why the case needs to proceed. So interesting there. But you also have a bunch of attorneys general across the country looking at what's going on in Illinois and in Cook County with the city of Chicago. The National Association for Gun Rights posted on X, liberal AGs release violent criminals back onto the streets. Those criminals commit crimes. Why would Glock do this to us? They ask tongue-in-cheek. And that's after Attorney General Matt Platkin out of, where's the Attorney General out of? New Jersey. They posted on X, Chicago suing over the ease with which Glock pistols can be turned into machine guns. Chicago's allegations are troubling, and New Jersey and other states sent a letter to Glock reminding them that we will enforce our laws if violated. And you have several attorneys general essentially telling Glock to preserve their records. And it'll be interesting to see how the Chicago case proceeds, because are they going to be, saying that they asked Glock to do this and Glock refused, and that's why they need to be able to sue? So clearly that's going to be an ongoing storyline important for us to track. But it's not the only thing that's happening in the gun industry. You've got the Guardian reporting that Arizona has a court that ruled that Mexico can proceed with lawsuits against 5 U.S. gun dealers. So this is kind of fascinating. A trial court in Arizona has ruled that the Mexican government may proceed in its trailblazing lawsuit against 5 U.S. gun dealers who stand accused of facilitating gun trafficking across the border into Mexico. So yet another case that'll be interesting to see some more headlines out of that. But as all of this litigation continues throughout the judiciary, you've got questions about new laws. And while most of the country now, 28 states or is it 27 states now have constitutional carry, where people can carry a firearm without having to get a permit. In the state of Illinois, we have concealed carry with permit. So you have to actually apply to be able to conceal carry in the state of Illinois. But other states have moved to remove some of those types of limitations. In the state of Virginia, the governor there, Glenn Youngkin, he vetoed a whole host of gun control measures that General Assembly passed in Virginia, including, as the Firearms Policy Coalition points out here, the Virginia assault weapon ban has been vetoed. So Glenn Youngkin vetoed that bill, along with a whole bunch of other legislation. So FPC doing their deal to ultimately target some of the laws that they see as troubling for the Second Amendment community. But back to Illinois, the Second Amendment Foundation, they post that they filed a brief in response to Illinois' motion for summary judgment in a law that challenges the constitutionality of banning firearms on public transportation. So in this case, they filed a response brief in that challenge of saying that you can't have certain types of firearms on public transit. And if you go to the Second Amendment Foundation's website, you can actually see a lot more detail on this. It's filed back in 2022. You got case documents, essentially an overview from the Second Amendment Foundation saying that Illinois law prohibits the carrying of firearms on public transportation or in public transportation facilities, even if an individual possesses a valid license to carry. This prohibition runs headfirst into the right to bear arms in public places and is contrary to our nation's history and tradition of where the carriage of firearms is prohibited. In fact, there were statutes which required the carrying of arms when traveling or away from home. So we'll see how that case proceeds. Of course, a lot of different ins and outs of Illinois laws and how they're being challenged. But when the state is defending a law, they're doing so on taxpayer dollars, right? I mean, the state is funded by taxpayer dollars. And the Firearms Policy Coalition points out that sometimes there are experts that make a pretty good living off this stuff. A lot of people, may chastise lawyers for, doing a variety of things to just make money. And sometimes lawyers are called ambulance chasers. Well, there's another industry altogether when it comes to the issue of experts and their testifying in these types of cases. So Firearms Policy Coalition, they highlight one particular expert in particular with a lot of money going their way. And in the case Harrell versus Raoul, this expert got $200 an hour per his brief to defend Illinois' assault weapons ban and standard capacity magazine ban. So just fascinating to see some of those types of things, especially whenever we look at the ongoing litigation in the state of Illinois and beyond. So again, let's take a look at that. Harrell versus Raoul, $200 an hour one expert got to file stuff. $150 an hour in Miller v. Bonta, Weiss v. Bonta, $150 an hour. Vanderstock v. Garland joined another brief supporting unconstitutional ATF rulemaking. So, a lot of interesting things there when it comes to just how much tax dollars go to pay experts to defend laws people say are unconstitutional. So a lot of moving pieces there. Hopefully it enlightens you this morning with Bishop on Air. Greatly appreciate you guys being here each and every weekday morning. Stay tuned. We've got Richard Pearson. He's going to be joining us from the Illinois State Rifle Association in just moments here with Bishop on Air.